We're going to start with the state of Ohio versus, John Dean, case number 18CA011290. The appellant, counsel for Mr. Dean, has waived his oral argument, so we will just be hearing from Mr. Murphy on behalf of the state. You'll have 15 minutes to present your arguments. As you know, the arguments are recorded and posted, so we ask that you remain at the podium and keep your voice up. And we have read your briefs and are ready to proceed when you are.
Good morning, judges. Excuse me. Brian Murphy, Assistant Prosecuting Attorney, Lorain County Prosecutor's Office. First of all, for the record, Judge, what I suggest to you this case is about is the possibilities of what could occur once incidents start to unfold when an item, in this particular case, perhaps what might be described as an unusual weapon, a billiard ball, is unleashed as a weapon. In this particular case, a fight broke out in a bar in the city of Lorain. It broke out in the area where the pool table is located. And as video surveillance showed, Mr. Dean picked up a billiard ball and launched it across the room at the individual who was hit, Mr. Rodriguez, in the head. He ends up, Mr. Rodriguez sustaining a lump on his head that's about 3 inches, that took 3 months to subside. Mr. Rodriguez testified at trial that 9 months later he was still suffering from headaches as a result of being hit by the ball.
Was there evidence that the head injuries were the result of that billiard ball as opposed to being kicked in? I noticed he had boot prints on his face.
Correct, Judge.
Kicking.
Well, Mr. Rodriguez testified that the lump began to form as soon as he was hit by the ball, is what he testified. I'd also direct the state, the state would direct the court to actually one of its own decisions from 2006, the Ramos case, cited in the state's brief. That's a case in which a plastic and metal beverage mug was used to attack the victim. And in that case also, the victim was hit by, as if I'm recalling this correctly, I believe I am, the defendant used his hands against the victim, and the victim also fell down some stairs. And what the defendant, Mr. Ramos, argued in that case is, well, you can't tell where those particular injuries came from. And this court said, well, some of the injuries had to have come from that beverage mug that was used. It was a plastic and metal beverage mug. And being attacked in the manner you were, or the victim was with that beverage mug, would constitute a deadly weapon. That you didn't necessarily need to make a line from the mug to the specific injuries.
So it's not what item is being used, it's the manner in which it is used and if it's capable of causing death.
Well, I think you have to look at the item used and whether it's being used as a weapon.
What about a sponge? It's stuffed down somebody's throat, I suppose it could be a deadly weapon.
Correct. And as the case law shows, the manner in which something's used. Someone throwing a sponge, of course, it's probably not going to travel very well. But if it's wet, sopping wet, you might be able to throw it a few more feet. No, a sponge is, I don't think, going to be a deadly weapon, but in addition to some other crimes that are likely occurring under the circumstances, if someone is holding somebody else down and trying to choke them, have them choke on a sponge, the state would contend that under those circumstances, a sponge could be a deadly weapon. The case law says that there could be some kind of harmless, just ordinary object, and you look at this, a billiard ball, you know, found in hundreds of thousands of even people's basements. And when you go into that basement, those balls do look harmless sitting on that table. However, when you pick up a billiard ball, launch it across a room at someone's head, I mean, you get a 3-inch, I believe was the testimony, lump on the top of this person's head. He sustains a concussion as a result of the chaos that's going on and being further attacked. A chip to his skull. Under the circumstances too, the ball is now, you know, someone arguably has seen this ball used as a weapon in the circumstances that unfolded here during the fight. And if someone picks up that ball, it potentially takes on the characteristics, again, the capability of it causing death, of something like brass knuckles, or you know, a couple of the cases that the state cited was a lock being inside of a sock in a detention facility. So a ball capable of being held in the hand and actually being used as a bludgeon, which in the circumstances it arguably could have been if someone had seen Mr. Dean throw the ball and realized that it could be used to hurt someone, takes on even that added dimension of hurting someone when it's actually picked up and held in the hand.
This was all caught on video.
It was largely caught on video, Judge, yes. The only reason actually the record reflects that Mr. Dean was identified as the person who threw the ball was the video. Because of the way the chaos unfolded, it wasn't, I wouldn't say that every portion of this incident was caught on video, but a large part of it was.
Was it necessary for the state to prove that he intended to injure somebody when he threw the ball, or?
Under the felonious assault statute, the mental state that's knowingly, is that Mr. Dean knowingly caused or attempted to cause physical harm with a deadly weapon. In this case, the state's contention was that the billiard ball constituted a deadly weapon. So knowingly, I'm not looking at the definition of knowingly right in front of me, but the probability that probability that circumstances existed. I mean, he clearly intended to throw the ball at Mr. Rodriguez, I think, who the testimony was trying to pull 4 people. Well, there were 4 people attacking a person, Mr. Messer, and Mr. Rodriguez is trying to pull one of the 4 people off. Those 4 people were associated with Mr. Dean by the testimony. So when you redo that case law and the cases that are the state sites that involve, for instance, out of the 5th district, the skillet, out of the 4th district and 12th district, combination locks that are in socks in detention facilities, the handle of a sledgehammer, which actually out of the 8th district was found to be a deadly weapon when it was used against the victim's legs. So the testimony was not that the defendant in that case attacked the victim in the head area or face area with the sledgehammer handle, but simply had attacked the legs, the left calf and the right knee. That's the Thomas case from 2009. There also, the thing that I think the string that runs through those cases is just the possibility that under the circumstances in which the way that item's used, so looking at it generally, not specifically, but whether something's a weapon, we need to look at specifically. The sponge is probably a good case of that. Is a sponge may or may not be a weapon. We need to look at the specific circumstances. But then that other, and it's really the first part of the definition of the deadly weapon, and whether it's a device that's capable of inflicting death, of killing someone, is to look at that in a more general sense. It's more of an, I guess I would say, an objective determination that the trial court, and obviously on review this court, would make is, under those circumstances, is there some way, in some way, shape, or form, could this item be used to ultimately really hurt and kill someone? Again, you know, you've got a billiard ball flying through the air, it ricochets back across the room, now someone sees it on the ground, picks it up, and now it becomes a bludgeon in the way that brass knuckles might be used, kind of analogously. Or, again, the lock in the sock in the detention facility. And again, the injuries aren't necessarily determinative of don't determine whether something's a deadly weapon, and that, again, there's plenty of case law in which weapons aren't even necessarily used out of its own district. There was a blow dart gun case in which the blow dart gun was constituted a deadly weapon. In those two cases, the combination locks, those weren't even used in the detention facility. They just happened to be found through searches and convictions for possessing a deadly weapon in a detention facility were upheld on appeals.
You got 4 minutes left. Do you want to address the claim of ineffective assistance of counsel?
Judge, I mean, I don't know that there's much to address in that from the state's point of view. If the court has any questions about the ineffective assistance of counsel, but just briefly, I think the most noteworthy point regarding that argument is there's no indication who Mr. Dean was defending. Mr. Dean's group of people were actually attacking another individual. If anybody had the right to defend anybody, it was Mr. Rodriguez defending Mr. Messer, which Mr. Rodriguez was doing, and that's when he got hit in the head by the pool ball. It was Mr. Dean's group, through a sequence of events that you trace backwards. The testimony demonstrated who started this incident by throwing the first punch. Mr. Roberson, I believe, was the individual who did that. Yeah, correct.
Well, does there have to be a relationship for him to come to the assistance of somebody who he thinks is in danger?
Well, I don't.
Could he have perceived that the victim in this case was in danger of serious physical harm or death? And
which victim? The judge, yeah.
The gentleman with the concussion and the chips.
Well, he's not defending him. What you've got, Mr. Dean's not defending Mr. Rodriguez. Mr. Dean hurts Mr. Rodriguez. Mr. Rodriguez is trying to pull one of 4 people off of Mr. Messer. That group of 4 people are people who are associated with Mr. Dean. So if Mr. Dean's defending anyone, it's these 4 people who all are attacking Mr. Messer. So one, Mr. Roberson started this whole thing, and 2, this group of 4 people is attacking Mr. Messer. They've started that attack on him. They could have retreated from that attack. And we'd also point out the trial strategy to this, which was, I think it was pretty evident from the record that Mr. Dean's trial counsel, his argument was this billiard ball is not a deadly weapon. That was the primary argument. If trial counsel starts asserting that he was acting in self-defense and is allowed to use deadly force, then he's conceding almost that it is a deadly weapon.
So obviously, I haven't had an opportunity to read the whole record, but The defense wasn't asserting that he was reacting to a situation and just threw the ball inaccurately hit this victim.
Correct. I don't know how that could be I don't know, from the way the evidence came out, I don't know how it could be perceived as him throwing the ball at anyone except for Mr. Rodriguez.
Thank you.
Because of the relationship between Mr. Dean and the four individuals who were attacking one guy, the guy who gets hit by the ball, Mr. Rodriguez, by the billiard ball in the head, is trying to help that one guy who's under attack by four people.
It's a lot of names, it gets a little confusing sometimes.
And obviously a bar fight can get confusing.
With that, you're out of time. Thank you for your argument this morning. We'll take the matter under advisement and issue our opinion in due course. Of course, the clerk of courts will mail you a copy of the decision once it is released. Thank you very much.